Your name, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, everyone. Welcome to the Appeals Court. Yeah, that's working. I apologize for our delay. There was some technical issue involving our recording system that I am assured is now adequately resolved, that we can move forward. I am Judge Rubin. To my right, Judge Englander. To my left, Judge Brennan. And we will be hearing, this panel will hear two cases, and then there will be a brief recess while we reconfigure the panel for our third case. Our first case of the morning is, at least allegedly, Commonwealth versus DeRozier, 22P551 is the case number. The rules are 15 minutes per side, and there is no rebuttal. And we will hear first from Attorney Kurasi.
Good morning, Your Honors. Andrew Kurasi on behalf of Mr. DeRozier, and if it may please the Court. Mr. DeRozier is entitled to a new trial due to two errors which caused the jury to speculate about whether he had refused the breathalyzer test. Since the evidence of guilt was weak, and the jury returned a guilty verdict immediately after receiving the Downs instruction, these errors likely contributed to the guilty verdict. In short, the court admitted a booking video with marginal, if any, probative value, despite the substantial risk of unfair prejudice from the breathalyzer machine being visible in the video and officers being seen manipulating and entering data into it. When the jury questioned the court as to whether DeRozier had taken or refused the breathalyzer because they had recognized the machine.
Can you, counsel, just move that microphone slightly toward
my
there you
apologies.
go. That's a little helpful.
When the jury questioned the court.
And then you just said something that I don't recall you saying in the brief. And although I did look at the booking video, I'm not sure I was able to see the entire video in what was shown to me. You say there was someone shown entering data into it. Now, that's not in either brief, so.
Yes, so at the end of the video, you can see the breathalyzer machine in the video, just for the record, is towards the right side of the screen. And towards the end of the video, you can see the officers go over and they sort of pull the keyboard down and they type into the keyboard. And that was objected to by counsel after it was introduced and shown to the video. I don't know, frankly, that I put that particular point in my brief, but if you do watch the video to the end.
You did not. Do we know that that was shown to the jury?
We do, yes. So we have a timestamp that was on the docket. They basically took a Post-it note and recorded the times that were shown to the jury. And we submitted a letter, I think just last week, to the court with respect to that issue, which was to say that they showed from the beginning of the video to 9 minutes and 40 seconds into the video. And so when you watch that clip towards the end, I think it's in the 9-minute. And
then there was an objection, you say, after that manipulation of the machine?
There was, and when you read the transcript, some of it was inaudible, but you can see the quote is something to the effect of them hovering around the machine, I think is the language that the trial counsel used. I think it's on page 51 in the brief.
How does entering data, typing on a keyboard, indicate to someone that that's more likely to be a breath test machine than just a laptop or a computer or some other device?
So I don't know that that makes it more likely that they would recognize the machine. I think that the issue with that is that it makes it more likely that their speculation would lead them to assume that he had refused the test. Perhaps not. But the argument is essentially if they're seen, they recognize the breathalyzer machine, not necessarily because they were entering data into it, but they recognized it. And if they recognized it and they see officers around it and typing on the keyboard, it lends itself to speculation that he refused the test.
To ask you a question, you indicated that it's of marginal value, and it just seems to me that that's an unusual argument because generally the argument is that body-worn camera or booking video is often the best evidence of what a person looked like, how they behaved, and whether and to what extent they may have appeared to be under the influence, as opposed to simply hearing officers testify about it.
Of course, and there are certain cases where that is the case. When the booking video shows evidence of intoxication, certainly it's highly probative, yet the video here...
Or the opposite. Which is more to typically the case, frankly.
Right. So here, the Commonwealth offered the video on the basis that it showed that he could walk on his injured knee. Right. Okay? That was the reason that it was admitted. So the court has to analyze whether or not that was probative to the case. And I suggest that it was not probative to the case because, one, It was not being contested. And two,
But how do we know that?
well, counsel said that.
No,
So-
but the jury is going to go do its own thing, right? And one of the things that the prosecution did put in is the evidence of the FSTs, as to which there was evidence that he told them that he had a bad knee,
Sure.
right? So the jury, in fact, we have a jury question about that. So the jury also was focused on what was the bad knee and what kind of impact
Sure.
did that
Well,
have.
the jury question was whether or not he was taking medication, but to the court's direct
Right?
question.
Ergo, they paid attention to the evidence that he had a bad knee.
Certainly. That is true. I
But
think.
whether defense counsel says anything about it or not, the jury may ask questions about it. The prosecution may want to put in whatever they have. No?
And that is true, but here, the evidence, I think, was clear that the injured knee had no impact on the field sobriety test. The
Are
evidence.
you arguing that the defense attorney didn't argue that the poor performance that was alleged on the nine-step walk-in turn was not poor, or that the trooper wasn't credible on that?
He did not argue that that was due to an injured knee. And to speak about those errors, in short, well, first of all, on the one-leg stand, his performance was excellent.
Right.
So that's part one.
Was there record evidence as to which leg he raised? It was.
I'm not sure.
As to whether he raised the leg with the knee brace on it.
Admittedly, I'm not sure, Judge. I actually think it might have been the other one, but I would have to confirm. But on the walk and turn, if this was a situation where he was stumbling around and his knee was buckling as he was walking and he couldn't keep himself up straight, sure, it's relevant. But here, the errors were that he missed heel to toe by a few inches. I think the testimony was by 3 to 4 inches on all steps. So if his injured knee was impacting that, it stands to reason it would have only been on one side. When he was using the injured knee, he missed 3 to 4, or perhaps the other way around. But he missed it on all of his steps, which is to say that had nothing to do with his knee. So, and also the trooper testified, frankly, that he didn't see any issues with walking. The gentleman was able to walk to the car without issues. This was not a situation where he was stumbling around and there was evidence that maybe he had issue with his knee. The fact of it was, there was no evidence that he had any difficulty walking. And so it's true, as the court points out, that there are certain times that the jury could draw conclusions despite a lack of an argument from counsel. But
Can I ask you just not to move off this, but on to your second argument for a moment? It continues to puzzle me, frankly, that the mere utterance of the word breath test somehow has such an impact on a jury that that a judge shouldn't say the word, that we don't presume that people know that they exist.
Sure, and I think that they do know that it exists, but of course the court in Wolf was obviously concerned about the Downs instruction, and the court went to great lengths discussing their concerns as to how a defendant should be able to elect whether or not a jury hears about breath test.
So two questions on that. Why is this not the rare set of facts that specifically directs the jury's attention to the absence of alcohol test evidence, i.e., they saw a machine apparently since they asked about it, so it's already there.
So what I will note on that is that the court has that line about it's possible that this may be necessary when there's a rare set of facts that draws the jury's attention to it. And appended on a footnote at the end of that exact sentence is their line where they say, even when a jury asks a question about it, you shouldn't give it. So I'd suggest that is indicative of the notion that the court did not consider a jury question asking about the lack of breath.
You were not the trial
I was not.
attorney, right?
I was not.
Is it your position that the trial attorney's proposed question was better than the Downs instruction? Proposed instruction in response to the juror's question?
So I don't know if it was certainly better to the defense case if it had been given. I don't know that I'm not claiming error that was not given. The error is frankly that the Downs instruction was given without a request.
And he didn't object to the Downs instruction until after it was given, fair? He proposed an alternative, and then when the judge says, no, I don't think that one works, because either A, it's not true, or B, it's just worse.
Right.
In effect, let me give Downs.
Right. His official objection seems to have come after the fact. I think reading between the lines of what happened during the discussion, it was clear that he was not asking for Downs. And he was objecting to Downs. He said, no, I don't want Downs. I want this instruction. The court said, no.
Actually, he didn't say that.
Well, he didn't say that. I'm paraphrasing.
He didn't say, no, I don't want Downs.
Right. But I think the
And he didn't say, you know, I don't know the dates where Wolf falls, but I think Wolf probably precedes it. He doesn't call the court's attention to the footnote and the fact that the court really
He did not.
would not be the preferred practice, right? That's
He did not.
You accept what the Commonwealth says about Wolf, right? You argue to us in your briefs, it was error.
Correct.
Wolf does not say it was error.
Well, Wolf does say that Downs should not be given absent a request from defense counsel. So in short, it was error because it was given without a request.
It says the preferred practice, and then it also says there may be unusual circumstances, and hence Justice Brennan's question, aren't these the unusual circumstances? I mean, as we also had in the recent decision in Marino.
Right. I don't think that it is, particularly in light of the fact that several other questions were asked at the same time, and I think that's important factually here, because what the court did is they have 3 questions seeking additional evidence, and the court said the box instruction. But then the court gives an additional instruction, the Downs instruction. And what that does is it segregates the jury's questions, the other 3 questions, from the Downs instruction. And what that does is it highlights the breathalyzer evidence as a particularly important piece of missing evidence. And so I think I don't think that it is the rare set of circumstances. Certainly their attention was drawn to it.
It highlights it as a particularly important piece. I might even accept that for now, let's accept that. But what they say is, ignore it. There's no evidence of breathalyzer.
Right, and I would suggest to the court...
Not consider it either way.
And I would suggest to the court that the SJC in Wolf was concerned about that instruction, and they talk about other situations such as the instruction about refusal to testify, that, well, if the defense doesn't want it, they have a strategic reason for it, they don't want to highlight it, it shouldn't be given.
But that was not the case here, correct? The defense did not express, I don't want that instruction, I have a strategic reason for that.
That's true, but Wolf doesn't require it.
Right. And are you suggesting that Wolf requires, or that any case that says the better practice requires a trial judge to apply the practice that an appellate court says is better, but not required?
I think that there's certain factual scenarios that the court may be free to say that it's not the better practice, but I think that when the Supreme Judicial Court says that this is the better practice, we don't want you to give it.
I think it
unless
says it's an error to give it in subsequent cases, even though it's relying on its authority to decide what practices are and aren't permitted. I don't think it's hortatory.
Sure, but I would suggest to the court here, frankly, ultimately, that where Wolf is saying you need a request, and I know and I appreciate he didn't say I don't want this, but I think that Wolf is saying, well, I know that Wolf is saying, absent a request from counsel, don't give it. And they analogize to the situation about failing to testify. The defendant.
So your argument that this is prejudicial turns on an assumption that the jury didn't follow the instruction.
So, an assumption, yes, although I think that there's actually some particularly strong evidence in the record that suggests that they took this Downs instruction and immediately turned around and gave a jury instruction.
What's the particularly strong evidence of that?
So, when you look at page 6 of the appendix, the docket sheet, the jury came into the courtroom at 2:13 with the 4 questions. The court gave their answer, sent the jury back, obviously took a few minutes. They came back in with a guilty verdict at 2:21. So 8 minutes from the moment that they walked in the door to be given their subsequent instructions, they came back with a guilty.
So that argument is, I know from the length of time what happened in the jury room, and what happened in the jury room is that they ignored the judge's instruction to ignore any evidence about breathalyzer, actually assumed that he had taken a breathalyzer and failed it.
Yes, that is my
I don't think it's
argument.
a matter of ignoring the instruction. Isn't the whole point of Wolf that because we don't know how a jury could use this instruction, because it's a double-edged sword that some jurors might think hints at refusal to take it,
Exactly.
it can't be given without the defendant's request. Because we're not going to do this, how many minutes did it take? We don't have to do any of that because it's an error to admit it. Now, how you want to prove prejudice, I don't know. Giving an erroneous instruction that could be taken to imply refusal, seems like that would be adequate to me, but your brother may have.
Can I ask you a related question?
Of course, yes.
Because you mentioned the failure to testify, defendant's failure to testify, which obviously is something that that instruction not given absent the defendant's request.
Correct.
What if a jury came back with a question, well, we didn't hear the defendant testify, what about that? Should the judge not use the word defendant testify in their response? Should they say, well, stay in the box? Or can they say, hey, folks, the defendant has absolutely no obligation to testify. You should not discuss that. You should not consider it. The burden of proof is on the Commonwealth. The defendant has no obligation not only not to testify or to testify, but not to do anything at all. Does then saying the words defendant and testify somehow create prejudice or create a problem there?
I think it's distinguishable in some ways, particularly in light of the jurisprudence surrounding the breath test, which is to say that, and this is the opinion of the justices, and the reason that this stuff doesn't come in is that we think that there's a risk that jurors will speculate about refusal evidence. I think that the defendant testifying is slightly distinguishable because I think without an instruction under that circumstance, they will speculate. But the answer, the response that the court in Wolf is saying is necessary here is effectively the box instruction. Don't speculate. They don't bring it up. They don't harp on it. And particularly in a circumstance where the court's already giving box in response to 3 questions. And then they take it further and they say, well, let me talk about that breathalyzer. And then they highlight it. They reinforce it. And they say, and here, I mean, and I'll just note, I know I'm out of time, but really the evidence of intoxication here was minimal, and I outline it in my brief. Really, the primary evidence of guilt here was the alphabet test, and I won't get into that, but there really was not much. And when you look at Wolf, the court there, frankly, the facts under Wolf were substantially greater for the Commonwealth. I think this is substantially less.
Your time has expired, so unless there are further questions, thank you very much. Excellent argument. We will hear now from Attorney Lee.
May it please the court, excuse me, ADH Lee from Middlesex on behalf of the Commonwealth. As to the question on booking video, the question is whether at the time of the motion limine, the trial judge properly denied the motion limine, not whether at the jury's deliberation, whether the judge properly admitted the booking video. The booking video in this case showing the defendant walking without limp in the booking room was probative to show that the defendant's failure on the 9-step test stemmed from intoxication and not from his knee injury. And as Justice Brennan pointed out earlier, it's actually also helpful to the defense. The relevance test is not exclusive reserved for the Commonwealth, but also for both parties. The bottom line is this is relevant to show the defendant's intoxication. It is also relevant to show that the defendant became less intoxicated from the time of the stop to the time of booking. This probative value was not substantially outweighed by the risk of unfair prejudice. The unfair prejudice here alleged is the presumption that a reasonable juror would recognize a BT machine in the booking video. In this case, there was no tube attached to the booking video. There's nothing indicating in the booking room that it was a BT machine. It simply looks like a printer.
Defense counsel says, hey, looking at the background of some of these jurors, they have experience with OUI. He gave a very specific reason why he was concerned about it, right?
Certainly, but that still does not exclude the fact that the video was more probative than the risk of unfair prejudice. And bottom line is, if the jury somehow recognized, like in this case, that really shows the need of Down's instruction. And to further respond to Justice Englander's point is, if the mere presence of BT machine in the booking video is exclusion, then the defendant sitting at the counsel table is also very risky because the jury would speculate at that point, why is the defendant not testifying? That comes as, again, the defendant not testifying instruction. This really just shows
Well, there may be a problem with putting a defendant at counsel's table.
My point is, it's
Except
just like
that they have a constitutional right to be there.
absolutely.
Well, but they don't have to sit at counsel table, maybe. Maybe they should be put in the audience.
Certainly, my point is the presence of the defendant or the BT machine does not necessarily exclude the Commonwealth from prosecuting the case. And if you balance both the probative value and the unfair prejudice, the video here is admissible.
What about Mr. Crossey's argument that the defense really didn't focus on his knee injury as impacting his behavior, his performance, I should say, on the FSTs at all? That really wasn't.
So around at page 99, where the counsel was talking about the FSTs, and that's really the main part of the closing argument, the defense counsel did commented on the defendant's performance on the field sobriety test. And the Commonwealth, both the trial and appeal, point out that it was probative for the Commonwealth to show that the defendant was able to stretch his leg during the booking video. He was able to walk without limp. He was able to bend down for at least 10 seconds. Those also shows that it's not coming from, the defendant's failure did not come from his knee injury, but it's more likely come from intoxication.
Do you agree with the assessment that this was not a terribly strong OUI case for the Commonwealth on the evidence?
I would say this case is stronger than Wolf. In Wolf, there was no field sobriety test, and in this case, there was an acknowledgement that the defendant had at least 3 drinks or 3 beers. He failed the 9-step walk and turn test.
Test was maybe the toughest one, someone
Yeah,
would say.
he stood on one leg for 30 seconds. That's pretty good.
Certainly, and he was able to choose.
Pretty good for someone who's had no beers at all, I got to tell you.
And he was able to choose which leg to raise, and to Justice Brenner's earlier point, the record does not show which leg he raised, but it comes down
And
to...
drunk people raise one leg but not the other? I was not aware of the sort of bilateral effects of alcohol.
I think the point to that was the injury, that he wasn't standing on
I
the
see,
injured
all right.
leg. Was that your
Exactly,
point
Your
on
Honor.
that?
Yeah. This case obviously is not the most overwhelming OUI case. There was no crash, obviously, but this case is not as weak as Wolf. Bottom line is, when the jury recognized somehow there was a booking video.
Somehow? How do you think they did it?
But it's not clear from the record.
No,
It could
it's
be
not
from
clear
the...
from the record, I agree, but I'm guessing one of them had seen such a machine before.
That really goes back to the Commonwealth argument again, that there's no common knowledge what a BT machine looks like. And if you look at a panel...
And I completely accept that, and that is the first sentence out of your mouth when you stood up, was, we have to evaluate what the judge did. And the judge, in any ordinary circumstance, would be able to say, look, it looks like a fax machine. I didn't know what it was. And so it's not common knowledge. But the problem with that is what I pointed out already. Someone said, look, the defense counsel said, defense counsel was right on top of this. And it was absolutely perfect as to this particular issue. There is someone there who may know what this is. And so I have an issue with it. Judge never responded to that.
Certainly. I would say at that point, the prejudice value is still speculative at that point. When the juries recognize the BT machine, that really shows the need for limiting instruction to the booking video. In this case...
Well, maybe you can go to that instruction then, because I've never seen a Downs instruction since Wolf given without a request by the defendant.
So Wolf was specifically to the initial charge. Wolf only dealt with when the jury had a question how to deal with Downs instruction in footnote 13, which is a better practice instruction. And last month, this court in Marino specifically pointed out the judge there was proper in giving the Downs instruction without counsel's affirmative
Defense
request.
counsel asked for it.
He did not ask for it in Marino. In Marino, the judge proposed the Downs instruction. The attorney would say it was fine.
But in fairness, we're not bound by Marino, right? We're bound by Wolf.
Exactly. My point is, this case is more similar to
I think
Marino.
actually we're also bound by Marino.
Okay, but Marino is not about...
On this, that's what I'm saying, on these facts. I didn't mean to say that.
Exactly. So on this fact, it's more similar to Marino than in Wolf, because this is not an initial charge. This is when the jury had a question. Like in Marino, the defense counsel did not firmly object or to say no to the Downs instruction. The judge inquire whether the defense counsel wanted the Downs instruction, which is like in Marino. And like in Marino,
Defense counsel said?
the defendant counsel proposed a different instruction.
I see, so that's the same as saying, no, I don't want that, I want this other instruction.
Not necessarily, especially given...
I love your idea, Judge, but give this totally different instruction instead.
I would say if you look at the specific proposed instruction, in this case is the Commonwealth is not using a breathalyzer test at all. Now also address the BT again. So the defendant is not...
If that's true, and of course I guess it wasn't in the record, if it's true that the Commonwealth was not, as counsel for the Commonwealth represented, I think, at trial, that the Commonwealth wasn't using it because the machines weren't calibrated yet, shouldn't the jury have been told that? Wouldn't that have been a much better answer? So then it wouldn't be a question of offer or refusal or anything. The machine was broken that day or wasn't calibrated. So that would give them an answer that's both accurate. Now, maybe it's not in the record. It's representation
It is not outside the record, but I could represent to the court outside the record that the defendant, the machine was used on the booking day, but that's not part of the record. So the defense counsel...
Yeah, I mean, that's a problem. What Justice Rubin's putting his finger on is a problem for me. I really wish there had been a record developed around this, because the suggestion by defense counsel would not necessarily be a bad suggestion at all if it were accurate. And the prosecutor doesn't say, that's not accurate.
I think the prosecutor's the one who says it wasn't calibrated that day. Doesn't the one lawyer says, I think this was during the time when they weren't allowed to use them, because there's some court order in place, presumably.
Certainly.
And then I thought it was the prosecutor who says, like, no, actually, it wasn't during that time period, but the machine wasn't calibrated.
So it was calibrated in 2019. And
How do you know?
So it was outside the record, obviously. So we think the record has nothing to show to support the defense counsel's proposed instruction. There's nothing in the record to show the Commonwealth is not using BT at all at this time. All I can respond is outside the record. Like, this machine was fell within...
I think that's fair.
So it was fell within Justice Brennan's and I's order in district court. But these are outside the record, so the proposed instruction was not supported in the record whatsoever. And the point is, the defense counsel was asking something that points to the BT. It's similar to the Downs instruction. Bottom line is, when the jury had a question on their own, that shows that there's a need for limiting instruction. In this case, it was the Downs instruction.
But the limiting instruction that's given was found by the SJC in Wolf to have a risk that it would focus or imply refusal. So that's not a limiting instruction that's useful, right? It's a limiting instruction that will be, at best, ambiguous. Otherwise, you wouldn't have a rule like Wolf, right?
I would agree if it's an initial charge, but the Wolf court did say...
Isn't it a harder problem? Now they say, and their question is, was it offered or refused? So someone has thought about refusal already, and now you're giving them the ambiguous instruction. I don't understand why that's not a problem.
I would say if you give the general instruction at that point, that's more ambiguous. If you give the Downs instruction, say, do not consider BT whatsoever, then that's a direct response that will put the jury's
I don't
question
understand
to
the word
rest.
ambiguity. There is no evidence with regard to the breathalyzer. You are not to mention it or consider it in any way whatsoever, either for or against either side. There is no evidence of a breathalyzer. Do not consider it in any way. Do not mention it, and put it completely out of your mind. Ambiguity?
No, there's no ambiguity.
There's no ambiguity, so you and Justice Englander are going to overrule Wolf. I look forward.
Can I ask you, and I should
Maybe
know
we
this,
just
but
read
in
it
Wolf,
differently.
your point is, as I understand it then, that in Wolf, the only instruction was the charge to the jury, as opposed to this case where the judge charged the jury, did not give downs, the jurors specifically asked about BT, and this was in response. That's how you say it's distinguishable from Wolf.
That's correct, and that's exactly what happened in Moreno.
Note 13, I think it is.
No, 13.
I'm sorry.
I don't understand the difference. I understand that distinguishes it. This also was in a different courtroom probably than the Wolf case. But why is that a distinction with a difference? Once
Certainly.
they've actually articulated a concern about refusal, doesn't it either leave it the same or heighten?
Certainly. So in Wolf, the court's concern is, one of the concern is, it might bring the jury's attention to something they don't know about. And the court in the footnote cited the study where if you tell someone not to think about something, that's the entire thing they'll think about. But when you have footnote 13, where the jury already has something in mind, it's unrealistic to say, oh, they're going to forget about it. No, they need the answer. And in Moreno, this court recognized there's a difference when the jury asks the question. And that's a distinction.
In Wolf is the only thing that tells you that what was done here might be wrong.
Correct. And this court...
Footnote is dicta.
Exactly.
It's flat dicta. It was totally unnecessary to the decision in Wolf.
I agree. And footnote 13, there's nothing in
You don't
Wolf...
think the holding of Wolf that a Downs instruction may not be given without a defendant's request might also have some bearing on this?
No, that only is limited to when, during the initial charge.
It says it's only limited. I've got it right here, so I'm going to look and check. But that seems, I don't recall seeing that.
So the court did not say specifically was limited to the initial charge, but I would argue that the court never said it applies to footnote 13. The court only offered a better practice recommendation in footnote 13, which this court recognized in Moreno and distinguished Wolf when the jury had a question on their own.
In fairness, though, Moreno was a different issue, right? That was ineffective assistance or the failure to advise the
It was
defendant. Okay.
It was defense counsel's failure to not know involve and not to reject the Downs instruction. However, this court in Marino, they recognized there was no error whatsoever because the judge did the proper thing. The judge properly exercised her discretion. The judge was the one who saw the evidence firsthand. She should retain discretion to properly address the jury's question in this specific matter. If there are no further questions, the Commonwealth rests on its brief.
Okay, thank you very much. Excellent arguments from both of you. Interesting case.
Excellent argument.
It is submitted. The next matter we will hear is Commonwealth versus Fagundes, number, where's the number? 22-657. I remind counsel that this is partially impounded. And we will hear first from Attorney Dame.
Thank you. Good morning. Michelle Dame for Paul Fagundes. May it please the court. The judge should have ordered a new trial based on the jury being exposed to extraneous information. Even one juror who is not impartial violates the defendant's constitutional right to a fair trial. There's a two-step procedure in place when the exposure comes to light after the jury has been discharged.
Dame, you concede, I presume, that the judge followed the proper procedure?
I do, yes.
Okay, thank you. Sorry to interrupt.
The judge was correct in finding that the jury had been exposed to extraneous information concerning what they believed to be a gang tattoo on Mr. Fagundes and that they saw him wearing an ankle monitor. However, she was wrong in concluding that the Commonwealth proved beyond a reasonable doubt that that did not prejudice Mr. Fagundes. The court looks to the probable effects of what this information would have had on a hypothetical average jury, taking into account such factors as whether the improper remark prompted an immediate reprimand from another juror, whether there was overwhelming evidence of the defendant's guilt, and whether the matter produced such a high probability of prejudice that error must be inferred. Now, I do admit that there was not evidence of extended discussion in the jury rooms about either one of these topics, but there was also no evidence that any of the improper remarks were met with an immediate reprimand by any of the jurors. I would also suggest that the evidence against Mr. Fagundes was not overwhelming. There was no physical evidence, there was no eyewitnesses, and there was no evidence.
Short of the victim?
Short of the victim.
Okay.
The victim's testimony here and her credibility was key. There was no other independent eyewitnesses, and there was no evidence other than the victim's testimony which corroborated the actual sexual.
Try to drill down a little bit on what it means for something to be extraneous.
Something that
is sitting at counsel table. Now, leaving aside Justice Rubin's speculation as to whether or not that's appropriate, he has a tattoo. The jury observes the tattoo. That's not extraneous, is it?
the extraneous information would have been the comments about that being a gang-related tattoo by the jurors.
Okay, so there's some comment by someone, and as I understand the evidence, it's extremely vague, but someone says something about how the tattoo might be gang-related. Might be?
There
Nobody
was...
says, I know that that's this gang, right?
It was not specific as to what gang it belonged to, but there was 25% of the deliberating jurors who admitted to hearing that the tattoo was in reference to a gang.
Would this have been different at all if this were an alleged drive-by shooting or a homicide that involved a gang style execution, if you will, if such thing exists? Is that different in any way, materially or importantly, as opposed to a stepfather, stepdaughter, sexual assault allegation?
I don't think so, because the reason that the court has urged caution against using gang-related evidence is because of the risk that's suggesting that the defendant may have a propensity for criminality or violence. So the concern with the tattoo here isn't that...
And that's criminality writ large? Because Justice Brennan's question, it seems to me, is a pretty good one, right?
But not only criminality, but of violence. And the testimony that the victim described here was very very brutal and violent sexual and physical abuse that she said that she sustained at the hands of Mr. Fagundes. So there was testimony that he had bashed her head into furniture, that he had drug her around by her hair into the bedroom when she would not go on her own. So these were it was a very violent sexual assault. And so here the jury deliberating that the tattoo he had was in reference to a gang, suggesting that he was in a gang and that therefore had this propensity.
It seems clear that these are things we don't want going on in the jury room. We don't want them speculating about whether a defendant is a gang member. We don't want them hearing about ankle bracelets that might imply, at least to them, past criminal wrongdoing. Ankle bracelets do say this person is in custody. We try to eliminate almost all signs of that for the defendant. You don't wear your orange jumpsuit to court. You wear some ill-fitting suit. You don't wear shackles or handcuffs. You're not gagged. You're presumed innocent. You get to sit there, ideally appearing presumed innocent. But the judge found that the jurors remained fair and impartial. What do you say about that?
I think when you combine the effects of the tattoo and the ankle monitor, we're not dealing with the jurors just were talking about the tattoo or they were just talking about the ankle monitor, but it's the combination of the two that would have, the average hypothetical jury would have used this evidence to find that Mr. Fagundes was a violent serial child rapist. And that was the inference that they were able to draw from these
So you think as a matter
evidence.
of law, the judge couldn't draw this finding of fact?
I think it's one of the factors that you can consider whether the matter produced such a high probability of prejudice that error must be inferred. And the combination of these two, there was such a high probability of prejudice that a new trial should have been ordered.
What's your best case, as in legal case, on that issue that's closest to this?
Unfortunately, none of the cases I could find were where they did actually order a new trial. But I think, again, when we're dealing with the gang tattoo, which leads the inference that a person is violent, and then the GPS monitor, which these jurors speculated as to whether that meant not only that he had prior issues or convictions, but prior issues of sexual assault. And I think it is important.
Where was that in the record?
Well, they were talking about him having the revolving door of ex-girlfriends, and that maybe this was the reason why. And I would note that prior to trial,
It's not the same thing as saying the ankle monitor indicates he had a prior history of sexual assault, does it?
they did speculate on convictions, and then if that had to do with him having a revolving door of ex-girlfriends.
But they could have been convictions for gang-related violence.
True, it could have been. It may not have actually specified sexual assaults.
Because again, I mean, I'm struck by, is it extraneous that he's wearing a GPS monitor? I guess it's extraneous because we think they learned that because they saw him walking in the courtroom rather than what actually they saw in the court.
That's how it was believed that they came to this information. But I would suggest the Commonwealth conceded at the hearing that it was extraneous information, and they were only arguing that it did not prejudice Mr. Fagundes. So whether or not this was extraneous information was agreed to by all parties.
Well, whether or not they agree, we may not, because, you know, the word extraneous seems to kick off a whole series of procedures. And I'm not at all comfortable with the notion that something you see in the courtroom is extraneous, thereby requiring the judge to have what happened here. You know, all the jurors have to come back in and be interrogated. So that's part of the reason I'm examining this.
I think it was more than the speculation about which of those things meant. It wasn't just, it was a tattoo of something that no one had any comment on. It was the comments that being gang-related, and then with the GPS of the comments being that of prior convictions.
Can I ask you a different question? So on the distinction between the indecent assault and battery, the vaginal touching versus vaginal penetration rape, I'm looking at day 3 of the trial, page 59, and the victim testifies, some days he would touch me, then rape me, and other days, et cetera, et cetera. Why is that not why does that not distinguish between the digital touching versus indecent assault and battery versus digital penetration rape?
She doesn't specify where the touching was or actually happened. And again, you don't actually need the intrusion into the vagina for it to be penetration. It's just touching of any part of that.
So you think there aren't two separate crimes, indecent assault for touching someone's vagina versus rape? You think it's always rape and never indecent assault?
There might be situations when it can be. In this situation, I don't think.
Wait, I'm sorry, say that again?
There might be situations where you can have both, but in this specific
Not
situation, I
both,
don't
just
think
one.
it is.
Can it ever be, never mind, how would I put this? Is there a crime, indecent assault and battery, for touching a vagina, or because of your thing about how broad the definition of penetration is it always rape? Is there some part of the vagina that can be touched without raping someone? So that it could be
The
charged?
case law says that it's any touching or contact with the vagina, so based on what the cases have said, seems that any touching of that, it would be. I mean, maybe if
Would
it
be
was.
The
rape.
argument is that
Would-
indecent assault is not a possible conviction that can come out of that testimony.
Out of the testimony in this trial, no, it would have either had to be, they would have had to find penetration, but there was no evidence of the incomplete sexual assault.
No, I'm sorry. I thought incomplete touching you just said was always rape.
That's what I was saying, is the testimony here, the jury couldn't have found anything but penetration, and so therefore could not have found anything less than that.
Doesn't she describe one time where he touches the outside of her vagina for some period of time before digitally penetrating her?
I believe it was always underneath the clothes, and if it's underneath the clothes, then I would think that it always would be, because again, it doesn't.
Always would be what?
That it always would be rape.
So your position is touching a woman or girl's vagina under their clothing is always rape, and only rape, not indecent assault and battery.
It does seem kind of illogical, but when the case law says that any touching or contact with the
What
vagina,
case
it does
is
not
that?
actually need intrusion, you do not actually need intrusion into the vagina to have it be penetration.
Okay, so what case says any touching?
Hang on, I don't, that would be the Donlin case, 436 Mass 329.
Right.
An intrusion into the vagina is not
I could finger on an
required.
issue that have been concerned about somewhat in our cases, and maybe you can help me. If the testimony is that this happened and it included a touching that our case law would define as penetration and therefore rape, the jury is incapable of concluding on that testimony that actually it didn't go that far, and therefore it was just an indecent assault? It seems to me that's your argument. The witness testifies, this is what happened. Under our case law, her description qualifies as penetration. Your argument is, with that testimony, the jury is incapable of coming in on a lesser included, or on a different offense, maybe not lesser included, of indecent assault, which would have occurred right up to the point of penetration.
Correct.
Is there a case that says that?
I think the closest one would be Commonwealth versus Ortiz, 47 Mass Appeals Court, which talks about the sort of incomplete sexual assault, and when the jury is not able to find anything but penetration, then they either need to come back with a rape
Not
verdict.
able to find it because the only evidence that was put in from the victim was that that's where he touched me. And the
Yes.
jury could not disbelieve that, believe that it was an indecent assault, but not rape.
Correct. I mean, going off of the victim's testimony,
Okay,
It
I understand your argument.
Fascinating.
if I could just briefly go back to the issue with the GPS. I just want to point two things out. If you look at the docket, trial counsel filed a motion to not only keep out the fact that there had been prior sexual assault allegations against Mr. Fagundes, but the fact that he had been in jail previously, and both of those motions were allowed. And so I think that shows the judge realized the significance and the prejudice that would have occurred had the jury been exposed to learning of prior sexual assault allegations or that he had been in jail before. But their speculation about the GPS would have led them to that same inference.
That's in motion in limine, part of the transcript that we have?
The docket references all the motions that were filed and allowed, and those were two motions that were allowed. There are.
But we don't have the motions themselves. We have the headings. We know what the title was, but we don't have the motions in our record.
And they were discussed at the motions in limine stage.
Oh, okay. All right. Thank you.
If there are no further questions, I will rest on my
Any?
case. Thank you.
Thank you very, very much. Excellent and very interesting argument. We will hear next from Attorney Nadeau.
Thank you, Your Honor. Good morning. May it please the Court. Stephen Nadeau on behalf of the Commonwealth. Beginning with the first issue, when Juror 3 brought her concerns to the Court following the verdict in this case, Judge Dupuis took the correct action following the procedures set out in cases like Kincaid and Fiddler. She brought all the jurors back in, questioned them about these so-called extraneous matters, and determined after those two evidentiary hearings that the defendant had not been prejudiced, and that was proven beyond a reasonable doubt. Her conclusion on that point and her subsidiary findings are not clearly erroneous, and for that reason, her order denying the motion for new trial should be affirmed. Excuse me. Beginning with, I'd like to address the question of overwhelming evidence, which was touched on in my sister's argument. I acknowledge that this kind of record, if it's viewed in the first instance...
Wait, you say there's no error, so why are you talking about overwhelming evidence?
Well, because that's part of the finding that goes into the analysis. It's those three factors. Was there an immediate reprimand? Was the evidence overwhelming? And what was the extraneous matter likely to produce such a high degree of prejudice?
So the subjective conclusion of the judge that these jurors were not or were able to be fair and impartial despite the extraneous information is not adequate? Is that right? Because if it were such that a reasonable juror would have been rendered unfair or partial, then we reverse anyway. So you have to, as soon as there's extraneous information, also demonstrate a lack of prejudice. Is that what you're saying?
No, I don't think any of the factors are sort of determinative, and the balance may be different from case to case. But here she did find that the evidence was overwhelming. And that may not always be the case, but where the extraneous matter is de minimis in some way.
What was I mean, it seems to me it's a balancing test, right? Some sort of sliding scale. What's the nature of the extraneous information that the jury was presented is the first question, right?
Yes.
Okay. What was the extraneous? How would you articulate the extraneous information the jury heard in this case?
Well, I think as to the so-called gang tattoos, I think Commonwealth versus Cologne, which is referenced.
Well, no, but what is the information factually? The jury heard someone say, I think those are related to a gang. I think those might be related to a gang. I mean, doesn't it make a difference?
I think so.
So what is the evidence as you understand it?
So I sort of agree with Your Honor's sort of confusion over how this is exactly extraneous, but I think it is discussing issues that are not part of the trial evidence, that was not brought before.
So even if it's within the jury room, and it's only the jurors who are speaking about it, that can still be extraneous?
I think that's what kind of Commonwealth versus Cologne says, where, similar thing, where there's some tattoos.
It's not in the record. Of course it's extraneous.
Right.
What if you had
I think that she has another child. There was a girl sitting in the third row. Yeah, you shouldn't be talking about that in the jury room. That's not in evidence. That's your speculation based on something you saw that wasn't from the witness stand. What was it, in the courtroom, outside the metal detector, at the barber shop, wherever you heard it? I don't understand this idea that it's not extraneous information if it's from a source other than the testimony at court.
Yes, Your Honor, I think that's how certainly the cases treat it. And, certainly in an abundance of caution, it makes sense to follow, I think, the Kincaid-Fiddler procedure.
Wow, I don't agree.
So let me ask you on that, what do we do with the judge's...
That's an extraordinary procedure to
sorry,
undertake because of an observation about what the defendant had as a tattoo. That's an extraordinary
What if he were
procedure.
wearing an orange jumpsuit? Would that be extraneous or not? What if the judge shackled him? Extraneous?
Well,
Seems extraneous to me anyway, but
of
perhaps
course, shackles
we
has a
should we'll have our conversation not during your 15 minutes.
What do we do with the
analysis.
judge's finding about juror 10, whom she apparently doesn't credit, who is perhaps the offending juror, if you will, if this offending is the right term?
She at least does not credit that he did not make the statement she found he made about the GPS bracelet and the revolving door of ex-girlfriends. But I don't know that she didn't discredit his testimony that, I didn't really think anything of it. I think he was probably embarrassed and knew he said something he shouldn't have. Probably a chatty guy, I don't know, clearly speculating, but as the judge found, the jury would have received that as speculation. No one thought he was, in possession of superior information.
So on the issue of the digital indecent assault and battery, well, the indecent assault and battery with the fingers versus digital penetration, can you distinguish this case from Collins versus Suero, which was cited in the defendant's brief, which seems to me to be almost the exact same facts?
Well, I think here, because there's sort of a progression from touching, he was trying to penetrate, and then he did, so there's a clear sort of demarcation there, and then she goes on to
How can
say...
there be a clear demarcation? Your sister points out correctly that in Donlan, the SJC says, the element, in that case, the element of penetration required for a rape conviction is established by evidence that the defendant touched or came into contact with the victim's vagina, vulva, or labia. Doesn't that mean that the touching on the outside is rape also, not indecent assault and battery?
I think, well, that is a straight sufficiency on...
If it
for rape.
is, yes, it's saying that the element is proven. If you prove beyond a reasonable doubt touching of the labia, beyond a reasonable doubt, that's a rape, says the SJC. So what is this indecent assault and battery that you're talking about?
The indecent touching...
Of what?
The vagina that did not include penetration, and that was...
This says penetration is proven merely by touching.
I think that may reflect sort of not wanting to, get into the weeds of how much penetration...
Well, what are you talking about? I don't know what that means, get in the weeds about. This is people going to jail because of this.
Right, but I think it's pretty commonly accepted that genital touching is...
Commonly accepted?
Indecent.
So this case is commonly ignored? I don't understand.
No, because that case does not purport to say that this is not an indecent assault and battery.
It's both crimes.
It can be.
Even though it counts as penetration, it also is indecent assault and battery. How can that be?
Because you're touching both.
Okay, but this says that touching anything.
Because it's a reasonable inference. This would be my answer to the question, sorry. But because it's a reasonable inference that if you are actually engaging in penetration, you've also engaged in something less than that, which is what our case law I don't think addresses this point, which is why the defense's argument is interesting.
I agree with that.
So I'm reading the Suero, and the facts there are, after backing away a little, the defendant slipped his fingers closer to her private and then proceeded to. Okay? That which I think is more, at least more clearly a multi-step process than we have there, was found to be just one crime. You can't have both an indecent assault and battery and a rape on those facts. So how does this case satisfy the requirement that you have separate?
Sort of what the verdict was there, but here it was very specifically instructed to the jury, argued to the jury that the conduct had to be distinct.
Well,
So
look, no, you go ahead.
So you're saying, though, if it happened, and if it happened 100 times, and the witness described it rather generally as it kind of happened pretty much the same time, was the jury then free to say, well, sometimes he might have touched, but he didn't quite get there, and other times, or aren't they confined to the evidence and the testimony here?
Yes, but I think those may be reasonable inferences from the testimony.
Sorry about that.
And
Well, I would have thought, I came in here thinking there was temporal separation between genital touching and genital penetration. And I thought, so that's two crimes, it's fine. I mean, we have these cases, Neal's and so on, that I don't really understand, that talk about necessary to the completion of the crime, as if you get a free pass to commit crimes on the way to committing another crime. If it's look, if he had to buy the gun in order to shoot the guy, well, that just seems nuts to me. So that's what I thought. But your sister has said, and I see it here in the case law, the crime here, there isn't a separate crime at all. Or there might be two instances of rape, but merely touching the external genitalia counts as penetration under the case law. And since penetration is an element of rape, I just don't see how you can say, no, it is. Now, maybe there's some subsequent case that finds indecent assault and battery based on the touching of external genitalia, and I'll find it and it'll show me. Are there cases like that? Do you know of a case where it was indecent assault and battery, not rape?
not off the top of my head right now, I apologize, but
No,
this wasn't.
it's not specifically applicable here, but you'll agree that indecent assault and battery on a child over 14 is not a lesser included offense of rape of a child under 16.
right.
Right, okay.
But as to that, I think, again, where the kind of dividing lines are clearly drawn kind of in the framework of the case from the instructions.
Why isn't indecent assault a lesser included of rape?
It can't be the age thing. I don't, again, that really wasn't part of the case.
Right, no.
So I'm not.
Different, it
Right,
could be.
yeah, so I mean, rape, so if this were not a child, in other words, if this were not a child, a jury could theoretically find a touching of a vagina as an indecent assault and battery.
Right.
It satisfies the elements.
Yes.
They're free to do that, but the problem here is the other, well,
There
okay.
was also a rape, part of it, yes.
Was the jury instructed what penetration meant?
No, but I think that's a sort of their common experience.
What does that mean in
No,
this
I think
context?
there
That
is-
can't be right. But there's all these holdings that are protective of victims of sexual violence that talk about penetration doesn't require more than whatever it is, some tiny touching, even aside from Donovan. You can't leave people, that wasn't really penetration. Well, that's not how to instruct a jury, is it? Use your common sense. Do you think
The jury was instructed on penetration. I read it last night.
Okay.
They were checked on the elements, which would include penetration, and the argument was you must find a touching without penetration, and that the rapes involved touching with penetration. So I think that's a clear distinction that was made before them. I think the testimony of the victim allowed for that conclusion, where she described sometimes it was rape, sometimes it was touching. Again, those are sort of in general terms.
So let me ask you, the same thing I asked Ms. Dame. The testimony of the victim that some days he would touch me, then rape me. The problem with that is in context, that's just after he's talking about the anal penetrations.
Right.
And so that if you really put it in context, or are you arguing that that would be sufficient for us to find that some days he would touch me, maybe the jury could say, well, that's the indecent assault and battery part of it, and then the times that he penetrated would be then he raped me on other days.
I think so, and
how do we fairly do that again when you look at it in the context of her immediately prior testimony about the forced anal penetration?
Well, I think even when she describes the first instance, it's again a progression from woke up, he's touching me, then he's trying to penetrate, then he does penetrate.
So I guess that's the root of it. If you have these cases, and that's what frankly, but if you have something that is a progression, it seems to me that the cases suggest that that's all one crime.
Yes, but then, she does say sometimes it's touching, sometimes it's rapes, and she goes back and forth. And I think, she's a teenager, she was a child when this happened. She's not certainly alert to the specifics of our case law on the matter. And I think, again, the jury...
I think it comes down to this issue, though, that I find sort of very common sense, which is the jury's also instructed they can believe all, none, or part of what a witness says. So if a witness testifies, this is where he put his hand, and the difference between indecent assault and rape is very small, right?
Right.
Because they're literally instructed no matter how slight, okay? The jury could believe that the hand was at point A but never reached point B, and that, it seems to me, would be legitimate to come to a conclusion that there was indecent assault but not rape. You follow what I'm saying?
Correct, I agree with that. And on that note,
Well, your time has expired. Thank you very much, both of you. Excellent arguments. More complicated case than I thought it was going to be. We are going to, the case is submitted. We are going to take a 3-minute recess to reconstitute our panel, and we will return and hear our final case after that 3 minutes.